Good afternoon, everybody. I'm Beth Grossman. I'm a junior barrister at Doughty Street. Thank you very much for joining us this afternoon. I'm here this afternoon to tell you about a recent case which I was involved in called Langley and GMB, and to look at the issues which arose in that case about the liability which trades unions may have to members in tort law arising from their arising from the advice which they give. Now I'm going to do something terrifying, which I've never done before on a webinar. I am going to share my slides. And here we are. It seems to be working okay so far. So the key question, so this is an issue which I imagine trades unions might be quite concerned by, but to my great surprise, when I did this case and I started researching the authorities behind it, I found that there was a dearth of case law, that this issue doesn't seem to have come before the courts on many occasions. And that this question is, when might a trade union be liable to a member for giving it negligent advice or assistance in the resolution of employment disputes? Now, when you think about it, giving members advice and assistance in employment disputes is the bread and butter of what trades unions do. And very often they do it through lay representatives who are co-workers, who are not qualified employment lawyers, who usually don't have a higher standard of general education than the people in the workforce they are seeking to assist. And the purpose is normally to provide practical advice in the circumstances. So, as you can imagine, there is an enormous scope if the lay representative gives advice, or indeed if a paid official gives advice, which the member later decides that they don't like, for that to come back and bite the trades union through a negligent action. And so some of the key questions I'm going to be looking at this afternoon are, does a trade union owe a duty of reasonable care to a member? What is the standard of care owed? When might a trade union be liable in an employment dispute for the advice and assistance which it's given? And how does this interact with the trade union's activities? Now, as I've said, unions deal with employment disputes day in, day out, and very often they'll give advice and they'll reach resolutions which their members are delighted with, but equally often they may well not. It's the nature of employment disputes that people often walk away, even when there's a settlement, feeling dissatisfied by the outcome. The mode of advice and assistance which they give does not come with a legal background or a legal focus, unless, of course, they refer the matter on to a lawyer. But at the same time, there are many cases where they might perform a similar role to that of an employment lawyer in advising, assisting, and negotiating. For example, they might support a member going through a disciplinary investigation. They might negotiate the terms of exit of that worker from the organisation. Trades unions rely upon political nous for the work they do, and they rely upon that model of lay representatives undertaking a largely voluntary role. This simply would not work if they were held to the standard of an employment lawyer. And if the standard of care which a union was held to was high or inflexible or a quasi-legal standard, then this might well have an impact upon the political nature of the work of a trades union. For example, the trades union might consider that the best outcome for an individual is a campaign involving the local press, or indeed a demonstration or a strike action. And that isn't advice that an employment lawyer would normally give. And if they were held to a standard equivalent to an employment lawyer, it might be difficult for them to use those sorts of tactics. The case I did in November 2020 before the High Court, I was hoping to provide a link to the judgment in these slides, and indeed the judge's clerk told me only a couple of days ago that the transcript was due to be with me later that day. But as so often happens with COVID, there has been a delay in it. So I don't have the neutral citation number, although all these extracts are from the judgment as noted, and I can send out that reported judgment to you once it's available on Bailey. This concerned a case of a shop steward, Paul Langley, who considered himself a rising star in the GMB. He was a refuse collector in Birmingham City Council. He'd previously been involved in industrial disputes and had engaged with the press as part of those industrial disputes. He was eventually suspended by Birmingham City Council for speaking to the press about a confidential matter without authorisation from them. And it wasn't a union matter he was speaking to the press about. It was about the fact that Birmingham City Council had decided to arrange some one-off refuse collections for fly tipping. They didn't want these matters publicised so that individuals didn't use it as an opportunity to get a free rubbish collection, and were understandably very upset when the publicity which ensued resulted in significantly increased costs for the council. After 9 months of negotiations involving Mr. Langley's union, there was a settlement between him and Birmingham City Council, and he got slightly more than 1 year's salary, as well as some additional benefits. Not long after that negotiation had concluded, however, he brought a claim complaining that the amount of compensation he'd received had been too low, and that he'd been denied the chance for bringing an employment claim, including a claim for interim relief, and complaining as well that the union hadn't looked at industrial action on his behalf. Now, one thing I should explain at this point is that Mr. Langley was acting at points himself or through a Mackenzie friend, and therefore some of his arguments were less than clear. But these were the aspects of the claim as found by Mrs. Justice Stacey and recorded in the judgment. So what did the GMB do on his behalf over the 9 months of his suspension? They briefed the press, implying that he'd been suspended for either whistleblowing or that his suspension was unjust because he was a trades union official. This they considered was, and this was in their evidence, was putting his case rather high. There wasn't anything in what he'd said to the press to really suggest that it was whistleblowing. They held repeated meetings with the council leader and the senior management team at the council. They'd got Mr. Langley's local MP, Jack Dromey, involved. They'd had 9 months of back and forth negotiations, at the end of which an offer was made, a revised offer was made on favourable terms. And at that point, as so often happens, it was referred to a solicitor for what we call terms and effect advice. So all of that sounds like the union did a pretty good job. And in circumstances where the official who represented Mr. Langley said that she couldn't see a whistleblowing claim or a claim against a trades union official being tenable, you might well think that getting more than a year's salary as an outcome was a very good solution for Mr. Langley. He didn't leave pursuant to any disciplinary findings, for example. But as I've said, Mr. Langley considered that the union could have done more. They could have given him the opportunity to have his day in court or used the pressure of that for a higher settlement. And they could have given him the vindication of a ballot for industrial action. Now, Mr. Langley's case was that the union had assumed a quasi-legal role, and therefore should have brought a claim on his behalf or advised him to do so, and that a reasonably competent union would have done more on his behalf. The union's position was that it had got the best possible deal for Mr. Langley in difficult circumstances. And the questions at trial were, what duty did the union owe? What was the standard of care? Was that a professional standard? Was that a quasi-legal standard? And importantly, did that standard change when it was a paid official advising and assisting the member and not just a lay representative? Now, I'm very pleased to say, as the representative for the GMB, that we got judgment for the defendant and a very favourable judgment. But it seemed slightly thornier than that at the time in terms of the law, and I'll briefly explain to you why. To my great surprise, as I said at the outset, when I came to research this area, I discovered that there was a paucity of case authority on this point. And in fact, there were only 2 judgments from England and Wales and 1 judgment from Scotland, which I could identify. The leading judgment in England and Wales is a case called Friend and Institute of Project Managers. It's from the end of the last century. Which doesn't that sound strange to say that now, but indeed it was. It's 21 years old as a judgment, and it does not go into a lot of detail. All it says is that the union must exercise the standard of ordinary care and skill, and that duty ends once a solicitor is instructed. And what a duty of ordinary care and skill means is that a union wouldn't be expected to advise on an injunctive relief application, for example. Now, so far so good, one might think, and that sounds like quite a basic standard for a union to meet. But the difficulty here is that what does ordinary care and skill mean in the context of what a union does? Whilst a union is clearly not a firm of solicitors, it is not walking in to advise someone or assist them in the same way as someone might be picked up. A union official, even a lay representative, is not the man on the street. And indeed, their raison d'etre is the fact that they have skill and expertise in this matter, in these sorts of matters. And then the question comes up as to what does it mean that the union's duty ends once a solicitor is instructed? Because very often solicitors are instructed on the basis of very narrow retainers. For example, if a solicitor is instructed to advise someone on the terms and effect of a settlement agreement, they normally wouldn't be expected to advise on the merits of a claim or quantum in respect of a claim. So can the duty really end just because there's a solicitor on board? These issues were investigated again by the High Court 14 years ago, 7 years after Friend, in Brunsden against Pattinson and Brewer and RMT. And in this case, the solicitor's firm's retainer didn't extend to the employment claim, and therefore the High Court found that the union's duty was ongoing. The union's representatives were aware that the claimant was very aggrieved and upset by his dismissal. They didn't advise him to appeal his dismissal internally or pursue a claim to the employment tribunal, and as a consequence of which he lost the opportunity to do so due to the limitation period expiring. And accordingly, it was found that the union had breached its duty towards Brunsden and were liable to him in the law of negligence. This case then provides a bit of gloss on Friend and Institute of Project Management, but it doesn't really take us any further in identifying what that standard of care and skill looks like in the context of a trade union. And the only other case on point I was able to come across was, in fact, a Scottish case, not that recent, but more recent than the other two, called Cosgrave and Accord Union. And this case made it quite clear that the duty to assist a member arises in one of two scenarios. The first is through the terms of membership, and the second is if there is an assumption of voluntary responsibility by the trades union. The question as to how the duty of care arises is important because it might also go to the scope of assistance which is promised to the employee, and therefore what the standard of care associated with that assistance might be. Now, in Langley, this issue came up. The question came up as to exactly how had the union agreed to help him. And on review of the GMB's rulebook, it was quite clear that there was no general requirement that a member in an employment dispute be supported or assisted, and there were no there were no requirements and there were no expectations set as to what kind of support or assistance that member might be given. It was, however, also clear from the rulebook that if a member wished to obtain legal advice through the union, that there were processes for doing so, and that the member could do that in certain circumstances without the authorization of the union itself. It could, so in certain circumstances, a member could go direct to an advice line operated by employment solicitors. And this was important because what it delineated was a couple of things. Firstly, that the union, not being under an obligation to assist, could determine the scope of what it could offer a member in the context of the particular employment dispute and the resources that might be available to it, and that the standard of care that it could offer would be determined in that context. Now, this wasn't a point that was picked up in the judgment itself, but I think that that ability of the member to seek legal advice, either by asking the union or by going directly to the advice line, is also relevant, because it shows that if the member is frustrated or unhappy about the service that is being provided, he has the opportunity to seek something different simply on request. And therefore, I think it would be difficult for a member to say simply, they didn't offer me the opportunity to go to see a solicitor, and to allege that the union had been negligent by not making that clear. The argument that was put forward on the GMB's behalf by me in court was that the duty which the trades union assumed towards Mr. Langley was to provide practical advice and support in negotiations, and using its political leverage as it saw appropriate to do so. That's my 2-minute summary. You don't need the whole skeleton argument. And the other point, which was significant, was that there was no higher duty of care, and no higher standard of care at play where the member was assisted by a paid official rather than a lay representative, that it was a standard of care offered by the union to its members. And the judgment, in the judgment, Mrs. Justice Stacey accepted this, and she expressly rejected any suggestion that the union might operate a quasi-legal standard of duty of care, even when it provided advice and assistance going to settlement negotiations, and even when, in order to do so, it needed to explore the merits of the case or the potential employment claim in broad terms. And what Mrs. Justice Stacey said was as follows: whereas here the union has represented and advocated in an internal investigation, it has a duty to provide reasonable care and skill by the provision of practical industrial relations and employment advice to the standard of a reasonably competent trades union. And one matter which was an issue in this case was that the official had made a judgment, had made a decision as to the merits of a whistleblowing claim, and had decided that such a claim in broad terms would be unmeritorious, and therefore that the union would better support Mr. Langley through political leverage by, for example, getting his MP involved and briefing the press, but not going so far as instigating strike action. And in order to make that decision, the paid official had, of course, been required to look at the prospects of an employment case and the merits of such a case in very broad terms. And what Mrs. Justice Stacey held was that that was acceptable. That was not the assumption of a quasi-legal responsibility. That was not the same as an employment solicitor or counsel as looking at that case. And a paid official could look at that case through the prism of the previous cases that they'd advised in, through their general knowledge as to employment law, and so on and so forth. The union is expected to provide the benefit of its experience, and that is its general understanding about employment issues, human resources, and industrial relations. It is required to be reasonably well informed as to the basic principles of employment law, and it is required to give strategic and tactical advice. That is when it accepts any duty of care towards an individual in the first place. And significantly, there is no higher duty where the union operates through a paid official than when it does through a lay representative. And this, I think, must be the right answer, because officials are not solicitors, they are not barristers, they are not independent professionals. They provide their services purely through their role as a union and purely through the existence of the union and their employment in that respect. And effectively, the union must be, therefore, indivisible, and no distinction can properly be made. And indeed, if the High Court had come to any other distinction, it would open up all kinds of issues. For example, the difference between different levels of lay representative, or different types of paid official. Mrs. Justice Stacey found that the GMB had met the standard because it had given reasonable advice on the merits of bringing a claim. In short, that such a claim would have been basically hopeless, that it had given reasonable strategic and tactical advice, and there was no requirement as part of the duty of care for the union to take any particular step. And in particular, it was recognised by the High Court that a strike ballot might well be an action of last resort, and that a union has to carefully consider whether it is worth either using or even threatening that sort of step in negotiations. And this is very important because, as I've said before, unions operate by virtue of their political clout and their political nous. It is simply not possible for unions to go on strike whenever a worker is dismissed or suspended, even if that worker is a shop steward or other union representative. And there would be a real risk if it was expected to take certain steps as a matter of course, that it would overplay its hand and it would lose its political nous and negotiating leverage with the employers. And so that is very important. Now, the implications of this case are, broadly speaking, good news for trades unions. There is absolutely no comparison with a lawyer or even with an HR provider. They're only required to have a reasonable level of knowledge of HR. And it allows for considerable flexibility, taking into account not just the circumstances of the case, but also the resources which the union has at its disposal. And it also impliedly understands that the advice which a union official or representative might give us to the merits of a case will be broad brush and based on general experience rather than any specific knowledge or detailed knowledge of employment law. The standard of duty will take account of what practical options are actually available. And there's also an implied understanding that the role of a union is fundamentally different from the role of an employment solicitor or barrister, even when the tasks being undertaken, such as support in an investigation or disciplinary hearing or assistance with settlement negotiations, might on their face look very similar. This, I'd say, is also very good news for employment solicitors and barristers, even if I do say so myself, because it emphasizes the different skill set and the importance and value of that skill set and what we can bring to the table. And indeed, one matter which is very important for a union is recognizing when it is hitting the limits as to what it can do under its reasonable standard of care. And if, for example, it needs to refer a matter for merits advice because there is a question as to whether it might be meritorious and the member, as in Brunsdon and Pattinson and RMT, is particularly aggrieved and wants to explore that option. What issues might arise? Well, as I've just suggested, I think the biggest risk for a trades union and the biggest area of potential liability in negligence is where it ignores clear indications from a member that they want to bring a claim, and therefore the union might be at risk on a loss of a chance basis, particularly if they ignored the member and the member lost out through a loss of the limitation period. The next biggest risk, I would say, is where a union makes very careless assessments on the merits of legal cases. Now, it doesn't have to make excellent assessments, and it doesn't even have to make particularly good assessments on the merits of legal cases, but assessments which don't, for example, take account of the different types of different types of whistleblowing, which don't involve even a cursory review of what might be available, might present an issue for them. Another issue that will arise, or may well arise in future negligence cases, is what happens where a union begins supporting a member, for example, at an investigation or disciplinary hearing, and can't continue to offer that support. Does the fact that it assumed an assumption of responsibility at one point mean that it owes a particular standard of care to an employee for any length of time? This, I would say, would go to the expectations that a member would have from the conversation it had when support was first offered to it, what the union rulebook says, and what the member understands is usual practice of that union in equivalent cases. Although, of course, every case can be considered on its own terms. There's a very flexible standard for a trades union, and provided there is a justification as to why it could not continue supporting a member, I would not say that that presents a particular issue in terms of liability. Where I think unions might find themselves at risk in future cases is where there's a refusal to support because of, for example, a political difference or a degree of personal animosity between, say, a lay representative and a colleague and rival. I've recently heard, for example, of certain cases where members feel that a unions refuse to support them because they have a differing political opinion, and other cases where they feel that a union has refused to support them because the lay representative or paid official doesn't like them. Now, as those sorts of anecdotes suggest, there is always two sides to every story, and no doubt a lot of individuals would rather believe that than the less palatable truth that they have a claim which isn't meritorious and which the union cannot devote time and resources to supporting in the way that the person wants them to. But on occasion, such an individual may well have a point, and indeed, if they are minded to bring a claim, it might be quite the battle in terms of a court hearing to dispel that point. And some of the matters which I think the court might consider in terms of a refusal to support is what the rulebook says, as I've said, and also what general policy a union takes towards supporting members who are associated with unpopular causes or members who are unpopular for other reasons within the workplace. That's all I plan to say on the subject. It's a fascinating and rarely explored area of law. I suspect that there might well be more cases arising in the future as perhaps inevitably following COVID, we will be seeing wide-scale redundancies and increasing pressures on unions to do their best with thinly spread resources across a number of different workforces. That's everything I had to say. If anyone has any questions, I believe we have a few more minutes left, and I'll stop sharing my screen now. I've had a question from Binda Bansal. Was the claimant's claim only put in tort? Was there no breach of contract claim based on the union's rulebook and policies? Yes, the claimant's claim in my case, Langley and GMB, was only brought in tort. And actually, when the rulebook was examined in the course of the trial and the associated policies were examined, it became clear that no better case would have been brought in breach of contract because there was no expectation set within the rulebook or the policies that assistance or assistance of any specific type would be available. Looking at some other questions. Paul Day has asked, what about where the union has its own in-house employment lawyers or where a union official also has a legal qualification? I'll take those questions one by one, and I'd actually be really interested in some of your thoughts on these as well. The reality is that most unions do have their own in-house employment advisors or associated or people with a knowledge of law associated with the union in a broadly in-house capacity. I don't think this would change the standard of care expected, because the purpose of what the union is there to do is not to provide employment law advice to that individual. It is to provide practical advice to that individual. And that advice might be assisted by a more detailed knowledge of employment law as provided by an in-house lawyer, but it would not become employment advice. The difference would arise if the union specifically assumed the responsibility of providing employment law advice. And I think that would require the union saying that they were going to do that and then passing the person over to the employment law advisor for that express advice. As to where a union official also has a legal qualification, again, I think that would only make a difference if the union official held themselves out as providing legal advice on the part of the union. And in those circumstances, the union, I think, would probably be maybe quite concerned as to what the individual was saying. But I think it would have to be in fairly express terms and fairly explicit terms that what they were doing was something distinct and different from the usual scope of employment advice and assistance. So thank you very much, Paul, for that question. That was really interesting. Do we have any more questions? Do feel free to put in the Q&A box or type into the chat function. It's a very interesting comment, Paul, in the chat box. Paul's just said, I'm mindful that many trade union officials are also tribunal panel members too. And yes, I think that goes to the scope of advice and assistance they can provide in their role as union official. And I think there might well be cases in which a trade union official drawing on that advice might be at risk of giving a member the impression that they're giving legal advice when they are not. So they'd have to be careful with how they expressed what they said based on their experience for panel. I've noted one person raised their hand. I don't know how I have to say how to answer your question. If you want to type it or raise your hand again, I'll do my best. Does anybody have any further questions? One person has asked us where we can see the recorded video. This will be sent out by Doughty Street afterwards. You'll also be welcome to receive a copy of my slides. And once the judgment is on Bailey, I'll be sending it out to all of you. I see Jill Kirk has sent a question, which is, could there be a potential implication for professional regulation for the representative? For example, the GMC or similar, if the trade union representative adversely impacted on their colleague? I think that's a really interesting question. I can well see the scenarios in which that would occur, and I could see the scope for disputes and legal disputes on that sort of matter. I have to say I haven't seen that argued in court. But I think it does raise actually a really interesting point that whereas an employment law solicitor or barrister is giving advice normally to one person or to a collective group within a workforce who all have the same interests. A lay representative might be called upon at different times to give advice to a number of people with conflicting interests. Indeed, they might well be called upon at different times to deal with people whose big grievance and rivalry is another person who's called on them for advice and support. And in those circumstances in particular, I think it is really important that a union is clear as to, first of all, the general impartiality of the service it provides, and is very clear that it ensures that everyone has access to proper advice and representation, whether that is from a lay representative or otherwise. And indeed, in certain circumstances, unions might well want to think about what to do to prevent conflicts of interest arising when lay representatives are advising within their own workplaces. We have 2 more minutes before the end of the seminar. Just seeing if anyone else has any more questions. Well, as it doesn't seem that there's anything else anyone wants to raise, I will let you get back to your desks on this January afternoon. Thank you very much for joining me. It's been a great pleasure to speak to all of you. Thank you.